Hey everyone, Harry here to talk about the E Jean Carroll case beginning on the 16th of January, beginning in a week. Remember this one? We've been focused on the 4 criminal trials, or maybe the big fraud trial that the New York AG had brought. This is the defamation. It's technically the first time that he defamed her. He then conveniently defamed her again after he was out of office. And there's been an immunity motion for this first one that's been bumping its way like a pinball all over the courts in D.C., in the Second Circuit, et cetera. Don't really need to summarize why, though it's been sort of interesting. But the main thing is that it hit the end of the road basically on Monday. The Second Circuit affirming the trial judge, Lewis Kaplan, said no immunity for defamation. And that also would mean, by the way, this came up at the very first charge, the DOJ won't stand in Trump's shoes. And had they stood in Trump's shoes, the whole thing would have gone away because it's an intentional tort, and the U.S. hasn't waived sovereign immunity for that. Anyway, we have this whole separate issue that's been bouncing around, but is now cleared out. He could apply to the Supreme Court for a stay, and if he got one, that would stop the music. I don't see it happening. He might, by the way, when someone applies for a stay, sometimes the justice who gets it from the circuit will do one temporarily, so the whole court can consider it. So could happen here, but I don't think so. All right, but that just clears the way for the final resolution of motions by Judge Kaplan. And man, he's been tough on Trump, and tougher still since E Jean Carroll won that first trial, because he has held the actual defamation is not at issue here. It's been established, and this is just going to be about damages. And so, it's not a question anymore. He did assault her. I remember this back in 1991. And he did lie about it, and he lied recklessly or knowingly about it. So he's guilty of defamation. How much should he have to pay? All right. But now they're setting sort of final rules of the road. And he set some tough ones, does Kaplan. You can understand. He doesn't. Trump instinct always is to, go outside the lines, do accuse or put the other side on trial, not only in a way that's nasty, but usually in a way that's legally irrelevant. This has come up, say, in the January 6th trial, where Chuckin has, been asked, don't let him say anything about how, he's been railroaded and Biden brought the prosecution away. The same things here. So we have a holding today that goes down the line for E. Jean Carroll and shackles Trump's lawyers in terms of what they can try to bring up in his defense. One thing they can't bring up, anything about her lawyer, who's a pretty well-known kind of on the ramparts warrior, especially representing victims of sexual abuse. She's also does high-profile activity, but we're not going to no talk about who they chose. This isn't relevant, or the activities that counsel does. Nothing about the funding of this litigation, which I presume it means people have paid, and maybe it's because they hate Trump, et cetera, but it doesn't have anything to do with the charges. Nothing about DNA, which I assume would be the absence of same. Remember, this event happens in 1991 in the Bergdorf Goodman dressing room. And so, it would be just so Trumpian to say, well, where's the DNA, in a sneering way? Here'd be another very Trumpian thing to do. And something that's happened a lot to victims of sexual abuse in the past, but there are much more strict rules about now. No, nothing about her past romantic relationships, this is the words of the court, sexual disposition, her prior sexual experiences. That used to be fair game in rape cases, maybe, some theory of having to do with consent, but really a way to sully unfairly the victim. So anyway, he's made it clear you can't do that. And then nothing to, get around the fact of the defamation. He can't try to imply that he didn't sexually abuse her, because that's been taken. He can't try to say he didn't know or he didn't have actual constitutional malice, as the lawyers say. In other words, that he knew or was reckless about it being false. That's been established. Can't try to say she made it up. That's been established. Everything about the defamation has been established. So he can't try to undercut it or try to get a second bite before the jury. So it's just about how much damage has she suffered. Presumably the first verdict comes in, maybe it goes to the evaluation of damages and the like. So I'm not sure about that. It's not part of the order. But here's the last thing that is part of the order. The Access Hollywood video will be received in evidence. So you may remember that. It comes out toward the end of the campaign. It's, gross locker boy Trump bragging to, I think it's Billy Bush, a cousin in the Bush family. And that's the famous account of his saying, if you're famous, they let you grab them by the pee. You can do anything you want, etc. When I think about this, I feel like a total naive child, because I remember thinking, okay, now Trump's finished. It's like he can't survive that, and that was 25 crises and total odious behavior ago. But anyway, the judge, more to the point, has ruled that it can come in now as evidence of Trump's state of mind. Now, I'm just going to, be a sort of new, computer type. But I taught evidence, and this would be his state of mind in 2005, and how exactly it would play out. And there is a rule that even if something is relevant, which is a low threshold, it still could be unduly prejudicial. So to my mind, this is he's created an appellate issue. I can see him making the argument on appeal. The jury shouldn't have been permitted to hear that, because it was, that relevant to the damages for the defamation either in, 2020, or if you want to go back to whenever it was. It really dirties him up. So we'll see. I do think Kaplan is an aggressive judge, and not looking to cut him any breaks. And if I'm Kaplan's clerk, maybe I recommend. I don't know if I want to do that one. We'll really hope so much, and it's a way to potentially get reversed. If that happens, of course, any reversal will be many years down the line, and maybe everything will all be forgotten by then. But that did kind of catch my eye, the last little part of Kaplan's order. So now we've got the rules and the guidelines, and next Tuesday, a jury is sworn, and they'll hear the Access Hollywood tape. There are a lot of things they won't hear, because they'll be instructed that it's a fact that he defamed her, and then they'll just go into damages. It's going to be a rough, not quite as rough as the fraud trial that is moving to final arguments there, but it's going to be a pretty bruising verdict for him, I think. And and after that, of course, we're starting to look at criminal trial season. 4, count them 4, possibly now. This is something for another day and another tape, but will in fact the Alvin Bragg New York DA case be the next after these two? But this is the next immediate thing, and there's going to be some dramatic moments. We'll see how much the jury is permitted to give punitive damages. So they could sock them pretty good. And we'll just watch how that all plays out starting next Tuesday. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.